sharing a screen with you, so I hope you see slides on your screen. And today we are going to discuss EU law. EU law, and we will take as example one area of EU law to understand you better how it works. Competition law, and also briefly we will discuss sources of law, and if we still have time, a few words about Lithuanian legal history. But just a few things. And first of all, we have to start to talk about European Union law. As you already know, there are a lot of different legal systems. Every country, every nation every state has his own legal system. So we have a lot of national legal systems. We have so much them as much as we have states in the world. So it's more or less 200 different states, 200 different national legal systems. We have one international law, and so it's somewhere above national law, because it's only one legal system as international law. But we also have European Union law. It's somehow also look, but maybe it's a kind of international law, because obviously it's not a national law system, but it's different. And in order to understand what are the differences between international law and the EU law, first of all, you have to imagine that when we speak about international law, we can imagine a settlement with a number of properties. On each on each of which stands one house with one family. Yes, and this settlement has no common government, no parliament, no court system, no police force. Each family deals with another family using agreements between. Sometimes more families come to one agreement, so maybe bilateral relationship. They exchange, mostly bilateral relationship, they exchange goods between and services. And when we look at such a settlement, and we can understand that each house is different state, as we can understand that something is missing in this legal order, as we usually understand legal order, because it should be enforceable. So who can enforce law in international law when we do not have common government, we do not have one court, we do not have police, and so on. So it looks that something is missing, yes? But sometimes somehow the system works because all states understand that they should cooperate, and of course there are some means which can guarantee this cooperation. Different sanctions, international organization, and other things. So it is international law, system of international law. And now we have EU law, EU as international organization, and member states, 27 member states, which are inside EU. And it is different from international law because we have common institutions which exist in European Union, differently from international law area. Mainly we have three main institutions in European Union, which are involved in process of legislation. We have the European Parliament, which represents EU citizens and is directly elected by them. We have Council of European Union, which represents the governments of individual member countries. And we have the European Commission, which represents the interest of the Union as a whole, like a government. And together, all these institutions produce legal acts, so they make such core decisions. This system is quite difficult to understand at the first sight, and which institution and how participates in the process of legislation, it depends on type of a legal act they produce. But in principle, the Commission proposes new law, and the Parliament and Council adopt them. And the Commission and the Member States then implement them. So, like government in national law system usually is responsible for implementation of the acts passed by Parliament. So, in EU we have Commission who is responsible for implementation, process of implementation. And of course, other member states, they also are responsible for the implementation of these legal acts. And also we have one more institution who participates in this process of legislation, and also participates maybe not in process of producing legal acts, but more for this institution is responsible for application of these legal rules. So we have Court of Justice of European Union who interprets EU law to make sure that it's applied in the same way in all European countries. Because otherwise we will be in trouble, because if will be now one institution who is responsible how everybody understands EU law, so everybody can understand it differently. Because law is such a thing that everybody has his own opinion on it. It's not a mathematic calculation where more or less everybody have the same understanding. Yes, law is different. And even if we have the rule which says very clear rule, but if we apply this rule in different legal system, we can get different result. So we need an institution who has to look after this process. So we have European Court of Justice of European Union. So differently from international law, we already have institutions who can produce rules for all of us in European Union, and we have one court who is responsible for application of these rules, that they be applicable in the same way in all member states, and tries to guarantee that whatever country applies, court of country applies the rule, the results should be the same. And it's differently. Also, there are more differences. When we look at the system of EU law, first of all, it's complicated system, but we will make it simple, because you don't need a lot about the system, but at least you have to know few basic things. And one of the basic things is that EU law is divided into two areas. It is primary and secondary law. And the primary law, it is treaties between member states. So member states agrees on something. It's like in international law. We have separate states which can conclude agreement or do not conclude. It's up to them to decide. Yes, and we have second area, secondary legislation. Secondary legislation is produced by European institutions, not by member states. Member states do not have direct power to create this secondary legislation because it is created by European institutions. So these two areas were very, very different in this EU legislation because uh, different actors and so different means. And first of all, about EU treaties. Uh, I'm sure you know that European Union was established by a treaty. So few states they came together and decided to make a treaty establishing the European Coal and Steel Community. No, it was the first treaty. Later we have eight, seven more treaties. The last treaty is Treaty of Lisbon. It was Treaty of Nice, Treaty of Amsterdam, Treaty of European Union, Maastricht Treaty, Single European Act, treaties of Rome, and so on. So we have a lot of treaties, 8 of them. They are concluded by member states. And when it's like a constitution for European law system, it's background of European law system. And usually when we need to look somewhere, we look to consolidated version of this treaty. So it looks like there is one treaty, but so all provisions are incorporated in this consolidated version. But sometimes if we need to know maybe what regulation are 20 years ago, so we have to take separate treaties and to look what it was written in them. And all these treaties, it is primary law. We call them by one name EU treaties. And every action taken by the EU or by EU institutions is founded on these treaties. So if a commission wants to create legislation, wants to produce a legal act, he has to find an article which is the background, which authorizes the commission to create this legal act. And this article should be found in EU treaties. There is no other place where commission should look for it. Yes, and so every action should be based on this EU treaties, because it's like a constitution. It's like in a national law system we have constitution, which is a background for the legal system. So EU treaties are the background for EU law system because they are created by member states. So these treaties are like starting point for EU law. So the name's primary law. And European member states of European Union, they agreed in which areas in these treaties they agree in which areas we are going to let European Union to create rules and which areas should be left for member states. Union has exclusive competence in some areas. It means that only European Union law can be in these areas. So it's, for example, custom unions, competition rules, monetary policy, trade, international agreements. It's the area where only EU law can exist. There is also shared competence, so EU or national governments can legislate. Both EU and member countries are able to pass laws, but member countries can do so only if the EU not already proposed a law or has decided that it will not. So it's like equal competences, but little bit European Union has more competences in these shared areas. So it's areas like single market, employment and social affairs, economic, social, territorial relationship, agriculture, fisheries, environment, consumer protection, transport, trans-European networks, energy, security and justice, public health, research and space, development cooperation, humanitarian aid. So a lot of areas. Maybe the biggest part of of EU law, it is with shared competences, where we can find EU law, but also the law of member states. So member state can also do something in these areas. And there is supporting competences. In these areas, EU can only support, coordinate, or complement the action of member countries. So it means that it's left for national legislation in these areas. Such areas as public health, industry, culture, tourism, education and training, sports, civil protection. And there are some specific competences where EU plays special role described in these EU treaties, for example, for coordination of economic and employment policies, implementation of common foreign and security policy. So we have different areas, and it is different competence who can create regulation in these areas, particular areas, EU or member states. And everything and all this is in European treaties. So we have European treaties, and everything should be based on them. And secondary law is all legislation based on created by European institutions, Parliament, Commission, and Council. And there are more different types of legal acts, but these 5 are let's say the most important. And the most important of them, it is regulations and directives. It's specific legal acts of European Union law, which exist only in European law. They do not exist in national law system, because you will see they are different. Maybe regulations, the first of them, it looks like similar law. It may be more difficult to read, because when the European Union institutions try to make it understandable for all different national systems of member states, the legal language gets very complicated, and sometimes it's very difficult to read. But regulation, it looks like ordinary law, because it is binding act, and it must be applied as it is. So everything what is written in them should be implemented, like we understand ordinary law. And just it's created not by Parliament, but it's created by EU institutions, mainly Commission and Parliament and Council. They cooperate together, and they create, in the end, we have regulation. And for example, when the EU wanted to make sure that there are common safeguards on goods imported from outside the EU, so we want to create exactly the same regulation in all member states, they adopted a regulation, because there is no place for different standing, because they have the same text. It should be in all member states. So it's a regulation, and it's directly applicable. So the national authorities have nothing to do, have nothing to create more to implement. It just everything applicable from the same moment it was created. Because we can find direct regulation, rules, direct rules, obligations, rights of different subjects. So usually EU adopts regulation when there is a need for uniform application of the rules in the areas which are the most important and in the areas where we need exactly the same rules. Sometimes it is difficult to achieve let's say, or to ensure this uniform application of European Union, or to create uniform rules, because maybe some states does not agree to specific rules. So in this case, it's possible to create another type of legal acts. It's a directive, and it's a legislative act that sets out a goal that all EU countries must achieve. And it's up to the individual countries to devise their own law on how they are going to reach these goals. Example can be European Union Consumer Rights Directive, which gives additional rights for consumers across the EU. For example, by eliminating hidden charges or costs on the internet, extending the period under which consumers can withdraw from a sales contract, and many more good things for consumers. But in this directive, you can't find exact rules how the state has to do. It is just the goal that the states have to achieve. Yes, they have to guarantee such a rights for consumers, but how they're going to guarantee, what will be the mechanism for implementing these rights, it's up to member states to decide, because all of them have different legal system, and so they need to have a space to create their own system, because it's not possible to create exactly the same system for implementation with goods in every member state. So the EU law here in this situation gives only goals. It's different from regulation, which in regulation we can find already rules which we have to follow, and directives is just what have to be achieved, and the regulation should be created by member states. So usually we have a period of time, and for example, this regulation should be created till the 2022 year. So, and government have to adapt the governments of parliaments of national states, they have to adapt their own laws and in order to achieve these goals. And if the government state fails to create the mechanism which guarantees the rights or fails to achieve the goals which are described in directive, the individual can go to the court and can invoke a question, yes, that can tell the court that, okay, look, the government made a mistake and now I'm suffering, yes, because my rights are violated. For example, as consumer, I do not get such rights which were in this directive described. So please tell the government to change a national law, because it does not achieve the goal written in EU law. Yes, and the court can take such an order. So it's, I hope you understand. Yes, there are very different legal mechanisms. In one situation, EU law use one mechanism. In another situation, they use another mechanism, which suits better. And so we have different legal acts as the result. Also, we have, but both the regulations and directives, they are binding. We have decisions. It's quite strange type of legal act because a decision is binding to whom it is addressed. It's usually to EU country or an individual company, but it's also is directly applicable, and it's suited for usually for particular situation. For example, Commission issued a decision on the EU participating in the work of various counter-terrorism organizations. So the decision is related to these organizations only. So it describes some rights and duties of these organizations. But they are binding by the nature, but just they are binding to whom they are addressed. They, let's say, decision always have somebody to which is addressed. As a company, usually it's a company, private company, for example, it can be all member states. We have recommendations. It's also type of legal act, and as you can understand from the name, it's not binding. It's sometimes when European Union institutions wants to start regulation, for example, in new area, and they do not have support for this new regulation, but they tries to promote some regulations. So they start from recommendations, because they understand, institutions understand that if they took a binding act, the member states disagree. So they starts from let's say some ideas, some recommendation how to create a binding legislation later in the future. So they suggest something. Yes. Opinion is quite similar as recommendation. It's also not binding. It's an instrument that allows the institutions to make a statement more in non-binding fashion. So it's just the institution tells us, okay, what's our opinion on this and this. And of course, it is without imposing any legal obligations. And it's not binding. And it can be issued by the main EU institutions, not only by Commission, Council, or Parliament, but also other institutions can express their opinion. Yes. For example, Committee of the Regions, one of the institutions of EU, issued an opinion on the Clean Air Policy Package for Europe. So yeah, you see there are different types. Some are binding, some others are not, but all they are created by European Union institutions, not by member states. So secondary law has always be based on primary law, and of course have no possibility to contradict them. Okay, let's look how it works in practice, and let's take an example of competition area. And competition area, it is area where EU has, as already said, it has this exclusive competences. Only EU can legislate. And of course, we have Also, usually some rules on competition in national law systems, but they are exactly the same as EU law. So it's like state can use it as model, but they can't create different regulation. And why we need competition policy and what it is about? Yes, and competition policy is basically about making sure that companies compete with each other on equal basis, yes, on equal footing. And this basis, they should compete on basis of the products and prices, and should be no unfair advantages. And European Union needs this rule to secure a proper functioning of European internal market, because it's the basic thing for European Union, yes, because European Union basically it was created, yes, for one single market. So this competition rule, they are very important to guarantee that this internal market, single market, works normally. And why we need European competition policy? First of all, we can answer to this question using five things. Yeah. First of all, we need low prices for all, because everybody understands that simplest way for a company to gain a high market share to offer a better price. Yes? And if we have a competitive market, prices are pushed down. So it's of course it's better for consumers. More people can afford to buy products. It encourages business to produce, and it boosts the economy in general. So it's good low prices for all, of course, except for the company who always want to set higher prices and to get a bigger profit share. So we need all better quality, because if we have competitive market, if these rules on competition works normally, so we have competitive market, and the businesses have to improve the quality of goods of services they sell, because it's only one possibility to attract more customers, more consumers, and expand market share. So we can do it in different ways. We can create products that last longer or work better, or better after sales service. Anyway, better service. Of course, it will result, competitive market result in more choice. Yes, because consumers can select more products, because companies offer more products in competitive market. If market is not competitive, we can end in situation where will be only one product, yes, and we will have to pay the price, whatever it will be, because it's only one product. And innovations area is to deliver better choice, produce better products. Business need to innovate. So in competitive market, they should be innovative, because otherwise they can't stay on this market. And of course, if the companies are better, can compete better in internal market in EU, of course they will be stronger outside EU. So they will be able to achieve their goals in international market. And competition puts businesses always under certain constant pressure to to create something to work it better. And sometimes companies try to limit competition because they want to get more profit and to cut their expenses. What we can do in order to limit competition? So we can create agreements between companies that restrict competition. We call these agreements cartels. We can arrange other unfair arrangements. We can abuse of dominant position. It's a situation where a major players tries to squeeze competitors, for example, out of a market using the dominant position. Sometimes companies try to merge with each other, so companies join forces temporarily or permanently because they want to expand markets and to get more profit. It's also a situation with financial support, state aid for companies. It's very important question, especially in our days, because governments tries to save companies, for example, in tourism sector, which are due to COVID pandemic, they are almost bankrupt. So it's a question when the state can help private companies. So it's not this area is regulated. It is competition policy because mainly the government should not support private businesses, because if you try to support private companies, you support one sector, so another sector can't compete. Or maybe if you support just few companies in one sector, so you can create a better position for them. So competition will not work in this area. So governments have very limited possibility to support by using financial aids private companies. So here we have competition rules, and we need competition law, because otherwise free market does not work properly by itself. Maybe 100 years ago, the economical theories have such an illusion that the free market is the best what we can have, because if government tries to intervene, always will be problems. Of course, there are some economical theorists still think about it, but most economical theorists agree that we need competition law, because free market can't regulate itself. Because if we will leave everything for free market, so for market regulation by itself, so it will end in dominant position, in cartels, in higher prices, and worse possibility to choose for consumers. So it's one thing you have to understand, because we need competition law, otherwise free market will not be regulated. There's not enough self-regulation. And second is that competition rules limit the freedom of the individuals or companies as in order to protect process of competition. As it's limitation. As, and basically everybody, when we took private law, everybody can act as they want. As for example, if we have a contract law area, So everybody can conclude an agreement whatever he wants. It's a basic rule. But there are some exceptions. And competition law, it is such an exception where state says, and here European law says, okay, you can conclude agreement, but please follow some rules. Or maybe in some cases you even have to ask a permission to conclude an agreement from government authorities. So competition law, it's a very huge area, but let's talk just about maybe four most interesting areas. It's about cartels, about dominant position, about merger control, and about state aid control. So cartels, what it is? It's interesting that cartel it has two meanings. First of all, first meaning is as agreement, specific type of agreement. It is cartel, and also cartel is a group of companies, is a group of similar independent companies. And usually this group of similar independent companies, they conclude the agreement which regulates something between or among them. And so we have a cartel as a group of companies, independent companies. It should be not subsidiaries, for example. And also we call this agreement on which this cartel exists. It's also cartel. Yes. Why these agreements are bad? Yes. Why it's prohibition? Yeah. Mainly, the main rule is should be no cartels. They are bad to competitive market. And if companies create a cartel, it is illegal agreement. And what it is illegal in this agreement? It can be legal different things, but first of all, usually these agreements can be open or can be secret, but usually they are secret. And this sometimes we are as agreements, so it's in written form, but sometimes they can be just an actions of companies, and still it will be an agreement because to agreement to be as agreement, you don't need every time a written form. So sometimes if you can understand from actions that companies agree on something, it can be a cartel agreement. So what it is always illegal. So if you have your own company, you can't agree with other company on these things. First of all, do not fix prices because it's always illegal. It seems what is it's bad. Yes, it's very bad, especially when it's a practice of big companies. Of course, if you have a small company, so maybe nobody will be interested, and you will not suffer negative consequences. You will not be fined by authorities who are responsible for competition in every nation. And just I forgot to tell that. Okay, now we speak about EU law as example. Yes, with competition rules, that more or less the same rules exist everywhere. United States, for example, we also have, of course, policy on competition. in competition area. It is little bit different. Little bit different methods are used, but the goal is the same. And where exist these rules on competition exist in more or less all modern economies. So it's always illegal to fix prices. It's always illegal to share market. Has to agree with, okay, I will work in this area with these clients, you will with these clients. It is illegal to limit production. I will produce little less.
I have a
Yes.
question. Why it is illegal to share markets?
Because you agree that okay, it's limitation of competition, because I know that I will work in this area, so I do not be innovative, because I know that my competitors are not working in the same area, so I will be only alone in this area. So the customers have no choice just to work with me. Yes, it's of course it's can be variation, but the basic thing is that in this sense you can't share market or consumers or customers yours, because the consumers have less choice, and it will lead for bigger prices or some other things. When I talk that it's always illegal, of course, it is economy, and it's always not so easy to understand when you are sharing market, or just you are, I don't know, maybe it's agreement of cooperation, and maybe you use some you try to join your forces in order to create new technology and so on. I will talk a little bit but later about it. But in main, and the competition rules is very complicated area in legal areas. So always we can find some exceptions. So when I talk that you can't share market, it means that I talk about that basic things. You can't share market, but in some situations maybe it will be not a cartel and you can share.
And limit the production, it's for the mass production stuff?
Sorry?
Limit production rule.
Yeah,
it's illegal for the mass production?
Yes, in this case, but also it's not only for mass production. Maybe you can limit production. I don't know, not for final consumers, but to other businesses. If you want to, if you want to agree, but it's for example, it's a very good example for limit production, but it's not a cartel. It's about fuel. Yes, about this not dieselin, but how we call it in Lithuanian, nafta.
Oil.
Oil. Yeah, it's about oil. Yeah, we all know that there is organization, international organization, which in this organization participates states which produce oil. Yes, and it is the biggest cartel in the world, because they agree, usually they always agree on fixed prices, on sometimes they agree to limit productions. Yeah, if a price falls down, they can sometimes they share markets and consumers. It's really a biggest cartel. But nobody it's like an as exception, because they are too powerful, but in reality it is a cartel, this international organization which regulates this oil production.
So these rules apply only to the specific areas that are not as strong, right?
No, maybe it's, let's say, it's not for states, yes, but for all other private companies, these rules apply. And you will see, I think I added also to practical exercises. Uh, you can find material. It's about, I think, about Google case. Yes, and when it was found, I don't, can't remember. It's, I think, about a fine was, but it was not about cartels, about abuse of dominant position. I think it's Google gets about it's 4 billions for violating EU antitrust rule. And you can go to the site and read about the situation. It's but it's a little bit different. Yes? It's not about cartel. I will back it to the cartels, but here it was abuse of dominant position. So it's when a company it is big, it's not a sin to be big. Yeah, you can be big, but if you are big, you have to follow specific rules. And if you slip somewhere, you are always watched by Commission in European Union, and they'll try to impose a fine on you, as they made with Google, and not once, few times. And here was situation about Android device manufacturers and mobile network operators, as the Google made some restrictions, and this restriction was seen as abuse of dominant position, and so the Google has to pay this fine to imposed by European Commission. About cartels, yeah. Let's go back. Yeah. Usually it depends on situation. I can agree that sometimes limitation production, maybe it can be good, but I am not an economist, and I can't describe what can be different situations with these cartels, but we use this as a general rule, yeah, that you should not limit production. On certain cases, yes, it's the same as the market share. Yes, but the first, sorry, can you repeat? Yes. And what does it mean? Oh, it is generally it is bad, but some. Yeah. Mhm. Yeah. Yeah. Mhm. Mhm. Yeah. Yeah. Yes, I got what you mean. Yeah, it is when we talk about distribution agreements. So we have, this vertical agreements. Uh, Cartels, it's usually are found on this, uh, let's say, horizontal agreements, when companies which exist in one level, and they make agreement, for example, to fix prices. When we have a vertical agreement, so we have somebody who creates the goods and somebody who later sells this good. So we have this type of vertical agreement, and one of them, it can be a distribution agreement. And yes, in these cases, it's possible to agree and to create the and to tell the price. Um, because vertical agreements, they provide more positive effects to economy, so they are like an exception from this rule. But even in these vertical agreements, in these distribution agreements, you can slip, and they also can be illegal. But let's not go to this area because it's even more complicated. But yes, if we have distribution agreement, no, otherwise you can't create distribution agreements without fixing some prices, because it's the essence of distribution agreement. So usually, let's say, distribution agreements can skip this rule. This rule does not apply for them. It's more for horizontal agreements, which between companies which are on the same level, not between manufacturers and distributors. So a lot of things can be bad in these agreements, but sometimes we have exceptions, as I said. And always, if we have something it's, for example, usually only the fixing prices, it's real bad, and almost there is no exceptions. In other cases, you have to also to look at these other things, because sometimes can be more positive effects. It can be concluded not between competitors, because always companies can tell, okay, we are not competitors. So if we are not competitors, so we can agree whatever we want because we are not competitors. We are very small, so we can create agreement because it does not affect all market. There are a lot bigger players, so it also can be as exception from these rules. And sometimes we need for new technology. So it's always when we have research, development agreements, technology transfer agreements, they are all usually compatible with competition law. And as I said, there is distribution agreements. Usually it's everything okay. But for example, it can be distribution agreement can be as a cartel. If, for example, a producer force retailers to decorate the shop or train staff in a particular way, okay, we can sell, your shop should be only, everything should be in this color, and it should be only in this way. Such a provision in the distribution agreement already can be illegal. Okay, consequences: a fine up to 10% of gross annual income. It's a huge amount. Personal liability for the manager of the enterprise. Disqualification from public procurement procedures. It's that if a company is for government orders. It also can be additionally, company can be forced to pay victims' claims for damages. Who can be victims? Consumers, other companies, and of course loss of good reputation. And you can later go to this site and see about video. There are 2 videos about when it's quite interesting how Commission, European institution, tries to find cartels because they are secured. Nobody announce loudly that, okay, press release, press conference, we concluded a cartel agreement. It's not the case. Yeah? They are secret. And how a company, institutions tries to find these secret things. So one mean is by whistleblowers. So if we have five companies which made a cartel agreement, agree on something what is illegal, and they all understand it. So that one company can run to Commission and tell, okay, look, we are all competitors, and we made an agreement. So I give you an evidences that there is such an agreement. And commission starts to investigate. And of course, if commission already has evidences presented by this company, and the end of procedure will be that the 4 companies will get fines, will be fined, and they will have to pay a lot. Sometimes it can lead to bankruptcy. And so it were 5 competitors, and now one who was whistleblower, so he is alive and happy, and others are with negative consequences. And sometimes it can be no more competitors, yeah, in this area, because always suffer it.
Where does the money go when they pay the fines?
To European Union budget, I think. So they have to pay this fine. It's for government if it's a case with competition institutions in national states, because European Union deals with cases where are very important and with big companies. If the companies are smaller, but they still can have a lot of influence in national market. So there is national competition authorities who deals with these cases. So if it's the situation with European Union, so the money goes to European Union budget. Yes, if it's case with national authorities, so the money goes for national budget. And plus, additionally, can be more negative consequences, and some other competitors or consumers can make claims and also get some benefits from this situation. But it's really very difficult to investigate cartels, as I said, because it is secret actions, and sometimes even there is no agreements, and usually there is no agreement because companies are not so stupid to write such an agreement and to take such a risk. Sometimes we just have an actions, and so it's even more difficult to understand if these actions were coordinated, it will be a cartel, or if this action was, it so happened. But usually in Lithuania we have situation when one gas station just makes a price bigger, and it happens with another, it's also made prices higher. And so how you can find a cartel? Now they both say that, okay, it's an oil price get higher, so we have to make our prices higher. So we are not a cartel. Yes, please. As I said, it's very difficult to find a cartel. And if we have such a situation, and if an institution who is responsible for this regulation or for implementation of these rules, they can make investigation, and they have, if they succeed to find something which can lead that it was somehow coordinated, yes, it will be a cartel. If a company succeed to prove that, okay, it's just a market, yes, we have prices higher, we have lower prices, and we have to adapt our behavior, but we do not coordinate between each other, it's okay. But if the authorities will find that before prices were raised, it was maybe some calls between competitors, between managers. Maybe somebody saw that they met in cafe. Yeah, they were drinking coffee. Yeah, it's like a criminal case. It should be all evidences evaluated, and it will be decision of government institution to fine or not, violated rules or not. And of course, companies can sue this decision to the court, and court once more time look at the situation, and the court can approve the decision of government institution, for example, to fine these companies, or also can dismiss, yes, this order to pay a fine. It's not easy to tell straight how it will be. Yes, of course, everybody understands that companies have to adjust their behavior to the market situation, but just will have not cooperate between each other. So not to coordinate actions, because if somebody will find, it will be not bad. It will be very bad. Okay, let's go to dominant position. As if you are big, it's, as I said, it's not prohibited to be a big company or to have dominant position, but you have to follow specific rules, because otherwise it can be abuse of dominant position. What does it mean? A company can, because company it is big, it can make some actions which can restrict competition. And how we can do? They can do in different ways. It can charge unreasonably high prices, which would exploit consumers. It will be bad for consumers, but consumers have no choice. Yes, because the company is big, it has, if it's big, it has a huge share of the market. But it can charge unrealistically low prices. Yes, and it's okay. It's good for consumers, but it's very bad for competitors, because especially when you hold such a position for longer time, you can squeeze competitors out of the market, right? And you will be not only a big company, but you will be alone in this market. Monopolist will be. So it is abuse of dominant position, either unreasonably high prices or unrealistically low prices. Both is bad. You can't discriminate between your customers. It's more not to consumers related, but to your customers. So you can't tell, okay, now I have there is a high demand on some type of raw material. So I will, I like you, you are nice, so I will sell you this raw material to you, and to other company, now I don't like, I do not want to sell. You of course, this discrimination should be very clear. Of course, sometimes you sell to one because somebody is paying you bigger price, of course it is normal. But in case if you want to discriminate on other backgrounds, it will be abuse of dominant position. You can force certain trading conditions on your business partners, because you are big. You can tell that, okay, I am going to cooperate with you only on certain conditions. It also can be abuse of a dominant position. The consequences is the same as with cartels. Okay, here's examples. Yes, it's a fine. It is restriction to participate in public procurement procedures, victims' claims, competitors' claims, and loss of good reputation. And here you can see this case. I can't explain this situation, but I think you almost maybe I know that you are more technically advanced than me. So it was the situation when Google required manufacturers to pre-install the Google search app and browser app Chrome as a condition for licensing Google Apps Store, the Play Store. I don't know exactly. And it was one bad thing. Actually, it were three bad things, and all three consist abuse of dominant position. Second, it was that Google made payments to certain large manufacturers and mobile network operators on condition that they exclusively pre-install the Google Search app on their device. And the third one was that Google has prevented manufacturers wishing to pre-install Google apps from selling even a single smart mobile device running on alternative version of Android that were not approved by Google. So it was so-called Android forks. I don't know what it is. But so it's, of course, it's not direct abuse of dominant position, yes, but these actions were found to be abuse of dominant position, so it ended in such a big fine. Merger control. It is the situation while companies combining forces. So maybe there are two companies, they want to join each other and to be only one company, and they can expand markets and, of course, bring benefits to economy. But it also can be bad because some mergers can reduce competition in the market. So it means that sometimes it can be good, sometimes bad, and that means that sometimes you need to get permission. Or if you want to make such a merger agreement with another company, you have to calculate what will be the end result. And sometimes you need to notify these institutions which are responsible for competence, for competition. Sometimes you do not need to notify them, but you still have to know exactly what is going to be in the end, how much market share you will have, and so how will be other consequences, because the European Commission, they supervise this area, and sometimes they can tell, okay, if you want to create a merger, okay, you can do it, but you have to follow such and such condition. For example, you have, okay, you are merging, but in 1 year, you have to sell one part of your business to another company. Otherwise, you have too much share. You will have too much share of the market. It is very difficult to calculate this exact what company is going to have, how much of a market it's going to have, because sometimes it's difficult to describe what it is market for specific product or services. But institutions, they have this experience calculating, so they can tell you, okay, you can make this, you can implement the merger, it's everything okay. But sometimes they can tell, okay, you can do it, but you have to follow our rules. Otherwise, you can't make such an agreement, can't make such a deal. And the third option, no. It's obviously, it will going to reduce competition in the market. You can't do such a deal. It's about merger control, and because it's about concentration. State aid control. Yes, it's about the situation when the state wants to help in certain situation. And now we have even specific rules which are related to COVID pandemic, because really now it's a situation where state has to help the private business. Otherwise, some companies, especially in tourism sector, um, airlines, were going to go bankrupt. And if the company is big, and if a big company goes to bankrupt, of course it is very bad for whole society. But still, these rules, the government or European Union, when wants to help companies, they have to follow this state aid rules, because the basic for such a regulation is that the it should not government can help only if it will be how to say, it's first of all, it of course, when you make financial support to one or another company, it always distorts competition. But at least with bad consequences should be less than if you do not support the company. But of course, there are a lot of rules how and when you can do this state aid. If you are paying not big amount to companies, it's not a state aid, because state aid it's from certain amount, and it depends if we are speaking about national level or European Union level. So if, for example, in Lithuania, government wants to help, for people who works privately, and so is paying some allowances, 200 euro, I think. It's not a state aid, so the government is free to do it. But if a government wants to make as financial contribution, or for example to buy shares from air company, it will be state aid, and it can be done only on certain conditions. So generally, it's not possible to help a private company, but on specific conditions, in external situations, the government can do it. Okay, and just we have few time left, so a little bit about sources of law. It's a place where we can find a law. So it's every system. Now we talk about national law system. We finished with international law and with human rights, with European law, and as example, competition policy, competition law of European law. And let's go back to national legal system. And where in national legal system we can find rules of law. First of all, it's constitution as supreme law of the land. Next step, it's all system is hierarchical system. Yes, hierarchically we can put all the sources. So the highest power has constitution, and later have little bit smaller power. Yeah? So it's constitution. Next level, it is legislation. It's statutes, statutory law. It's law produced by parliament. A little bit lower, we have executive branch and the legal acts created by executive branch. It's president, government, it depends on which country. Uh, Sometimes some legal system, they have shared legislation, and it means that legislation, so power to create the acts of highest power, it is shared. For example, in some areas the government also can create new legislation. But for example, in Lithuania, uh, government have only executive power, and government should implement what is produced by parliament. So the government has no power to create new regulation. It, of course, it can produce legal acts, uh, but it's only on the background of the law uh, produced by parliament. And also we have courts. How court can create is the source of law, and it can be done in few ways. First of all, the court can decide cases and create rules by deciding cases. In some countries, it has more power to create new rules. It is common law countries. In other countries, it has less power. Civil law countries, as in Lithuania, the court, the judge usually have possibility to explain how to apply the rule, but not to create a new rule. So it's one way to creating legal rules. Another way is called judicial review, and that means that the court has power to revise or to decide if the legal act produced, for example, by parliament, by government, is compatible with constitution, for example. Sometimes it is the duty of common courts, sometimes it's a duty, for example, of a constitutional court, just. It depends on the system. So constitution is always a background. As in European Union law, EU law, we have treaties between member states. So national legal system, we have a constitution. It's framework for legal system, and all other legal rules are based on constitution. Legislation, statutory law, yes, it's passed by legislator, usually it's parliament, and it should be in compliance with constitution. As court, decision of the courts, yes, it's, as I said, it's case law, it's judicial review. And also the source of law can be part of international law, which is by some means transferred to national legal system. So we have EU law as example, we have trade treaties which impose, for example, some tariffs. We have World Trade Organization, which creates rules how states should be trading between each other. So it's also source of law, and also bilateral treaties between different countries, which when they are ratified by parliament, they becomes a part of national law. So they're all here. We have places or sources where we can find a law, and because law it is system, so every this source of law have his own place in this system, and it depends on legal system. As different countries have different system, almost all have these sources, but they have different power, different meaning, and different place European legal system. Also, there are other sources such writings or books of legal scholars, of legal scientists, but it's a secondary law source of law. It's not so important because, of course, the scientists can't create legal rules. They just can explain, but okay, maybe it will be better to apply in this way. Maybe we should create new rules which will be better, but it's only recommendation. In some countries, it can be rules created by king. Still, we have monarchies in some countries, or ruler, another type of ruler. We have, in some countries, we have religion law as very important source. For example, Sharia law. And we have no time with Lithuanian legal system, so I just want to tell one thing, right, about Lithuanian constitution. It was in 1791, and it was the first European constitution, and it was second in the world. And the first constitution in the world, I'm sure you know, where it was, in United States. And it was a very modern constitution, and it has only 11 articles, but the main thing that it was all basic democratic solutions. Yes, it was established a principle of sovereignty. So we have power of a state divided between parliament or legislative branch, executive branch or government, and judiciary branch, the courts, as with basic classical democratic features. And it was established in this constitution. And it was very modern source, and it was other countries, European countries, where this constitution was analyzed in universities in other countries. But the very bad thing that this constitution has power only for 1 year. So it was very good legal act, but it lasted only 1 year because it was a different situation, and it was war between Russia and Poland, and so the Lithuanian state was later divided, and so the constitution ceased to exist. But it was first European constitution, and it was a Lithuanian constitution. Of course, this not full democracy was established because these principles of sovereignty, they applied only to nobility and townspeople. And still, people who live in villages, they do not get significant rights in process of democracy. But this nobility and townspeople, they get some democratic rights. So that's all for today. Maybe you have more questions? Or questions?
Thank you.
Not yet.
Yeah, please. So,
no questions yet.
No more questions. Okay. So try to go to find information on practical exercises. If you are interested in competition law, you will see more. It's also, I added one case on competition. I can't remember. Is it with Google? I think it's Google, but another case with Google. So you can read this case, and it's also explanation. I added explanation of this case. So okay. So we meet next week.
All right. Goodbye.
Thank you for participating. Bye.